So, welcome everyone to week 4, and tonight we talk about the topic on statehood and recognition. So, we know that in international law, the most important subjects would be states, and mainly because states are the source of most of international law, because they create international law, especially in the form of treaties. So whereas if you talk about customary international law, which can take a while to evolve and to be established, as far as international law in the form of treaty law is concerned, that's quite easy, because if you have two or more states agreeing to enter into a treaty, then you have established international law. So states are important, and which raises the question of, what exactly is a state? Now, we recall that at the end of World War II, when the United Nations was first established, there must have been less than 60 states then. But as of today, there are probably about 183 of them. So there have been a lot of states which have emerged, been established in, especially the 1990s, especially with the breakup of the former Union of Soviet Socialist Republic. Is that, does that concept still sound familiar to you? The younger generation will not remember that. They wouldn't know what exactly is the USSR. But to those of us, including me, was part of the Cold War era, when there was the threat of, the nuclear war, the war of mass mutual assured destruction between the United States and the USSR. We know what the USSR is, and we would have been exposed to Gorbachev, Glasnost, and Perestroika. And after the breakup of the Soviet Union in the 1990s, you had a lot of states that were established, including Belarus, Ukraine, I think that's part of the USSR, and so on. And of course, to the younger generation, who were probably born in the, what would that be, 1990s? Yeah, for some of those who were born in the 1990s, they would have been too young to know about the USSR. So some of us as well would have been exposed to the genocide in the Bosnia-Kosovo wars. You've probably heard of that, Mladic and Karadzic and so on. When we would have thought there would be no genocide that would happen during our time, but it happened at that time in the 1990s. And as a result, there were a lot of, but that happened because of the breakup again of the Yugoslavia. And you have the Slovak Republic and so on. There was even the Czech Republic, which broke up into Czech Republic and some other state. Which leads us to the question: when can you have a state? This is a crucial question, for example, because if we're studying public international human rights law, it is important for us to. Kathleen just got from China. Okay. It is important for us, if we're studying public international and human rights law, it is important for us to be aware about what's going on internationally, about what's going on among the states. So for instance, some of you may have come across what had happened, what was it, around last year. You've heard of, the state of Catalan, which is part of Spain. And they had a referendum to declare independence. And so they wanted to become an independent state. But what happened then was that the premier of Catalan, which is they were trying to become a separatist republic, an autonomous republic of Catalan. They were then, he was then sought to be arrested by the federal government of Spain. So, which brings us to that question: if he had actually tried to assert that there was a state of Catalan, which is independent of, the how do you call Spain? It's a monarchy, but if it's as a separate state from the state of Spain, would that have, would that actually have led to the existence of the state of Catalan? What exactly is the status of Catalan now? You've also heard, I'm sure, of the current incident, which again figured up in the Ukraine. Are you familiar with that? You should be. Last week, where the Russian Navy fired at some Ukrainian ships, and I think they arrested about 24 sailors of the Ukraine Navy. But before that, was it in 2014, Russia or Russian troops invaded part of Ukraine, which was, the Crimea. And in fact, there was an attempt to establish the Autonomous Republic of Crimea based on that part of Ukraine, which was seized by Russia. Okay? Would there be a state? I mean, is there, could assuming that, the people living in Crimea decide to say that, we have a government, we say that we are now a state, would there be a state of Crimea? Good questions, right? Some of you may know that in the Philippines, there is there has been a war with the, what they call the Moro group. It's called the Moro Islamic Liberation Front, or it used to be called the Moro National Liberation Front. And they were trying to establish a Moro state. In fact, some of them would say that there is they call it the Bangsa Moro Republic. They're trying to say they're a state of their own. Are they therefore a state? So these are very interesting questions in international law, mainly because if you have a state and it is recognized in international law to be a state, then that particular state will be the subject of rights, powers, and obligations. So for example, if a state is in fact a state in international law, what it would mean is that it would have the right to diplomatic immunity. So it could have ambassadors, it could have diplomatic personnel, and they could venture to have relations with other countries, and those persons would have diplomatic immunity because part of customary international law is the immunity from arrest of diplomatic representatives of states. So which is why some of you may have come across incidents in the United States of diplomats just parking illegally on the streets, and they couldn't be arrested. If you had the ambassador of some state deciding to park in the middle of M3 and block the traffic, even if that was an illegal act, that diplomat couldn't be arrested by the Queensland Police or even by the Australian Federal Police because of diplomatic immunity. So that's one. And we also know that if a state is a state, that state would be would have the right to and the power to territorial integrity and territorial sovereignty. So if another state were to enter its territory, that would be violating the norms of international law. So that it is, it is entitled to certain rights. It would also have the power, for example, to enter into trade relations or relations with other states, enter into treaty relations and so on. So there is an advantage, therefore, to states becoming states. And so therefore, we need to ask the question, when is there going to be a state? Okay, so those are the critical questions that we need to ask. So tonight, after studying this topic, you should be able to discuss and explain the rights, duties, and powers of a state by virtue of its legal personality as a state, the criteria for statehood, and the effect of recognition by other states on the de jure existence of a state. And related to this question is, what's the distinction between a state de jure and a state de facto? And what exactly is the whole point about recognition? So, because when we go to the quiz question tonight concerning the state of Palestine, for example, important states such as the United States and Israel, well, I call them important because maybe it's really that Western-centric feeling that, these are important states. But the United States and Israel, for example, do not recognize the state of Palestine. But an overwhelming number of states do recognize the existence of the state of Palestine. In the last vote in the United Nations, there were 9 objections. I think there were 9 abstentions and 2 objections. But the rest of the members of the United Nations voted to recognize the state of Palestine. Does it mean, therefore, that the state of Palestine is in fact a state? And does it mean that it automatically has the right to membership in the UN? So questions like these are crucial questions. There are also questions like, you might have come across, what's going on in the South China Sea, in the territorial dispute there, where China has decided to put up reefs, artificial reefs. And they've even put up a military base there. They've now got a military base there with naval ships and guns and aircrafts. Now, if and what if at some point they decided that at some point they may abandon one of these artificial places, and somebody decides, like Richard Branson says, oh, I want to put up a state in that artificial area that has been created. Can that be a state? And we're going to examine that. Remember the movie of Waterworld, for some of you who were in my generation? Kevin Costner? You remember that? Or not? You missed a good movie. Kevin Costner, Waterworld, where the world was inundated, and the only places for people to live was in some artificial places in the middle of the sea. They were using ships and vessels as the islands. Do you remember that movie? Well, you missed. That was a fantastic movie, at least when I was younger. Well, the question was, could Kevin Costner have declared that we are now a state? I mean, something like that. Somebody, decided to put up a state on the basis of some naval vessel that has been sunk somewhere. Okay, so these are questions that we would like to examine tonight. I've actually prepared 6 questions, including the quiz question. So let's begin with question 1. Can I get somebody to read question 1 for us? Just a volunteer, just to read the question.
I'll do it, Manjo.
Okay, Peter.
Teletoys, a company registered in Kandoma, entered into a contract in 2003 to supply Rutamanu's State Department with 500 plasma units during the reign of General Blast in Rutamu. Although the military junta overthrew the democratic government in 2005, Kandoma never recognized it until it was overthrown in 2008 by another military junta led by General Ru. Teletoys has brought an action against Rutamia following the refusal of General Ru's government to pay Teletoys money due under the contract. Ru's government argues that since Kandoma never recognised Blast's government, it cannot bring an action against it. Advise Teletoys.
Thank you. What do you think? So the facts indicate that the Kandoma.
I think that once the government has been recognised by a foreign government as being a state, as per the US recognising the 2 governments of the what became the USSR, that this would be a similar sort of situation.
Very good. And so what would your answer be, Peter? What would your advice be?
My advice would be that they can get payment. That they should be able to sue for payment.
Okay. So, and would Kandoma's would Rutamu's existence as a state depend on on whether or not its government is recognized by other states? And what if there is a change in government such that the government, for example, is one that the international community will not recognize because it might be a dictatorship, it might be a communist government, and so on. It might be involved in genocide. Would that affect the legal personality of a state as a state?
No, I don't think it would. Once it's been recognised, it goes back to the initial part of recognition. It goes back to the original recognition of the thing. The USSR, the government that in the case of the USSR, the government of Tsar Nicholas II was overthrown in 1916, and there was an interim government. And then 1917, the Marxist government came in and overthrew that particular government and created the USSR. Now, the American government had recognised the previous government to the USSR, and the International Court of Justice ruled that their recognition went back to the first government.
Very good. So fantastic, Peter. That's a very good answer, and with historical facts added in. Fantastic. So regardless of the type of government, any changes in government, for as long as there is a state, that state will continue to exist. And if you follow, especially the case of the Western Sahara case, there is no requirement in international law that any particular state should follow a particular pattern or any particular structure. It could be anything. And because there is a diversity of forms as far as governments are concerned, and that will not affect the legal personality of a state as a state. So here in question 1, there is no question about the existence of the state of Kandoma, and even if you may have 2 warring governments trying to assert that they're the governments, it doesn't change the fact that you do have one state. So Peter's answer is correct. Now, the other point that needs to be established here is that some of you may have heard of acts de jure versus acts imperii versus acts iuri gestionis. So when governments act, they can act in a government capacity. They can also act in the form of pursuing certain commercial interests. So it could be that in acting in a government capacity, it could be about entering into military relations with another state. It could be about entering into trade relations, about agriculture, about food, and so on. It could be about health, and so on. But these are, clearly what we may call government acts. But states also do act in a commercial capacity. It may be that it engages in banking. It engages in, there might be a national airline owned by a state, and it enters into relations with another state. And the question is, given the fact, as we said, that one of the primary rights of a state, once it is a state, is the immunity from suit. That is based on customary international law. So let me repeat, under customary international law, a state is immune from suit in another state. So you cannot, for example, in Australia, you cannot sue the government of the United States or Japan or Russia or whatever. For whatever they do, you cannot, because that would violate international law. Okay. Now, the question, however, is there a distinction in international law between government or sovereign acts of a state as opposed to private or commercial acts? Can somebody tell us about that? What do we recall about it? Because that's crucial to question 1 as well.
Manjo, if you were to sue a government, it would have to be done in its home country, not necessarily you couldn't sue the United States of America in Australia. However, you could sue them in the US.
Let's assume that the United States government has certain commercial properties in Australia. They may own a building. They may own vehicles. They may even own planes. If you will recall, I raised this question, Peter, because if you recall, again, this shows how old I am. During the, 1980s, the Iraq invaded Kuwait.
Hey, I'm older than you.
I do, okay. Do you remember the invasion of Iraq? Invasion of Kuwait by Iraq? Do you remember that time? Saddam Hussein? That was, Kuwait 1 or Iraq 1 and Iraq 2. And what had happened then was that Iraq was made to make reparations to the state of Kuwait, or Kuwait. How do you know? I don't know. I'm not sure how to pronounce it. And certain planes and assets of the Iraq government were actually seized because, you know, the United States government, for example, may have money in banks. And the question is, can those be the subject of forfeiture or confiscation or you know, some other legal action by a state?
Yeah, but didn't that come about because it was government to government, not government to private enterprise?
But so that's really my question. What if it is a government acting in a private capacity? For example, let's assume that, you know, the state of Indonesia imports oil from Saudi Arabia. It's a sovereign act. It's the state of, not Indonesia, it has a lot of oil. It could be the Republic of the Philippines. It could be it could be Japan, which imports oil from the Saudi Arabian government. Okay, it could be the Saudi Arabia buying military weapons directly from the United States government. It's a purely commercial transaction. Now let's assume that, you know, these governments decide, you know, we're not going to pay, and it's a multi-billion-dollar contract. Would that be correct under international law? They cannot be sued because under customary international law, states are immune from suit?
Aren't we talking about the difference between public international law and private international
law? Not exactly. And I'll discuss the distinction shortly. Not exactly.
I think in that particular case, Manjo, you've got an International Court of Justice case where a government-to-government situation, one government reneges on paying another government. But where you're looking about a government-to-private enterprise situation, I think that then comes down to a case of suing the government in its home country.
Okay. Yeah. So the crucial point here is that. Sorry, wanted to say something.
Yeah. Sorry. Yeah. I actually came across something that may be related. Came across it in my sort of travels reading for the lecture notes the other day. In the last couple of days of the case of Philip Morris in Uruguay, which is a private company suing the state of Uruguay about. It's Philip Morris is a multinational tobacco company, and is suing the Uruguay government for compensation because of the anti-smoking legislation that devalues cigarette trademarks.
Okay.
It's from 2010. And it was originally decided in 2016.
Okay. I'll address that in a short while, Jack. Okay. Very good. Thanks for raising that point. Let's just discuss the basic issues here. So in relation to international law, we make a distinction between acts imperi, or sovereign and government acts, as opposed to acts iuri gestionis, or commercial and private acts. So when a state is undertaking acts that are known as acts imperi, or government or sovereign acts, that state is immune from suit from any court of any state. That is a core principle of international law. Okay? That's a core principle of international law. Are we clear? Now, but the moment that a state enters into commercial transactions and undertakes what is known as acts iuri gestionis, following the case of the owners of the ship Philippine Admiral, Philippine flag versus Wallen Shipping, it is a basic principle of international law that there is no state immunity for acts iuri gestionis. So for commercial acts, it is possible for a state to be sued by another state, or even by a private entity. And it also means, therefore, that once a state enters into a commercial transaction, it also means that it has given up its right not to be sued. So in international law, we make that distinction. It also means, therefore, that any act that the state does, for example, it ends up killing, committing genocide, you cannot sue that state for the acts of genocide. People, even if you have relatives and, you've got people who were killed, you've got relatives who were killed, you cannot sue the government because that would still be considered a sovereign act of the state, even if that act might be illegal in international law. Okay, so we're clear? Now, so that relates to the point raised by Jack in the case of Philip Morris versus the state of Uruguay or Paraguay. What was it? I'm not sure. The crucial point there is that it is very difficult for a state, or especially for a private company, to sue another state on the basis of its sovereign acts, like a legislation that it passes, unless, for example, it entered into a commercial transaction with Philip Morris, which said that it guaranteed that Philip Morris could continue to operate in that particular state, and it will not pass legislation, that type of thing, maybe, okay? Because in that case, it can be said that there was a commercial transaction between that state and maybe a private company. But if it is, if there was no such contract, and it is all about, a government action, a state action making a decision to ban smoking, you cannot sue a state. Okay, and I'm going to go back to this question a short while from Kathleen. Couldn't it be done in an international court? Okay, let's make a distinction about international court, because we don't want to use that concept of international court loosely. Okay, maybe perhaps if you talk about the International Court of Justice, which is an organ of the UN, the subjects of the ICJ would ordinarily be states and not private companies. Now, there are also international courts in the sense that there are international arbitration courts. And these are normally international commercial arbitration courts. A lot of them are found in Singapore, Hong Kong, Belgium, in the Netherlands, and even in the state of Delaware. So there are international commercial arbitration courts. And that's where a lot of litigation goes on, even against state governments, against states. Okay, so we'll make that distinction. Now, let's make a distinction, because Dean raised a valid point about public international law and private international law. So when we talk about public international law, we're referring mainly to law that governs relations between states. When we speak of private international law, some would say that the use of the concept is actually misleading, because private international law is really not international law. It's actually called, kind of conflict of laws, because in that situation, when you talk of private international law, what actually happens is that you have private parties. You're not talking of states and states. You're talking of, maybe a citizen of Australia and a citizen in the United States, and they have a dispute maybe about child custody. The question then is, which laws will govern, that issue about child custody? It could be about the validity of a marriage. Somebody married, for example, in the Philippines, divorces are recognized. And let's assume that there is a Filipino national married in the Philippines and marries an Australian citizen in Australia. The question is that marriage valid? Under Philippine law, it is not. In Australia, it would be. And what if, there are properties involved? What legal regime do you impose? So that's called private international law. It doesn't involve states. The question really for private international law, what is known as conflict of laws, is, which laws in the event of a conflict will actually govern. And okay, so we're clear about that. Now, let's go to question 2. Thank you, Dean, for raising that point. Question 2. Can I get somebody to read question 2 for us?
I can read it.
Okay. Dean, yes?
I was hoping you'd put it on the screen, it'd be bigger, but I'll read it off my one here. Jacques Smith, the Premier of the province of Wario, a population of over 4 million, has been fighting for the independence of his province from the Commonwealth of Lanario, a federation of provinces. His actions are motivated by what he perceives as a failure of the federal government of the Commonwealth of Lanario to properly meet the needs of the province of Wario. A referendum legally organised by Smiths in his province overwhelmingly expressed support for the independence and creation of the state of Wario. Such separatist initiative of the province of Wario was vehemently opposed by the Commonwealth of Lanario, which refused to support the former's plan to declare independence. Smith has come to you for advice on whether he can declare the existence of a new state of Ontario. Advise Smith.
Thank you, Dean. Now, this appears to be a hypothetical question, but in fact, it has a lot of parallels in real life. Okay, as I mentioned, the Catalans trying to create the independent state of Catalan, and that's where Barcelona, I think, is the capital is Barcelona, which is well known as a capital. They were trying to declare themselves independent of Spain. You must also be familiar with Canada, where there was a referendum. There has been an ongoing referendum for Quebec to become an independent state. And let's assume that the referendum succeeds, and I don't know how you call them, but the people of Quebec say that they are now declaring the state of Quebec. But the federal government of Canada does not agree with it. Can there be a state of a Quebec? We will recall as well in the UK that there was in the 1960s to 1970s, and I think it waned in the 1980s. But there were ongoing wars between the UK government and the Irish Republican Army. And Jack would be very familiar with this. Jack, can you tell us about that? Would you know about that?
The IRA.
Yeah. What was that about?
That was about Irish independence from the United Kingdom. It was a very, very bloody revolution. It actually claimed the lives of several members of the royal family at the time. But because it took Lord Mountbatten, uncle of Prince Philip, took Princess Anne, one of the Queen's sisters, if I remember correctly, over the Irish sovereignty of Ireland, as well as Northern Ireland, which Northern Ireland ended up staying as part of the United Kingdom.
Yeah, so
the biggest problem there, Manjo, was the fact that Ireland was separated in 1919 from Northern Ireland. They separated the whole thing. It used to be, it was just totally stuffed.
Okay, because I'm sure a lot of Australians have Irish roots, right? And so I don't even know if that's it could be a sensitive issue. But the question for us is, if the Irish Republican Army and the government of that particular part of the UK, the Ireland, because there is an Irish Republic, right, which is different from that of the IRA, wasn't that a state? If they declared that they were a state, they even had their own military, right? So that's a point. You have these things going on, and so in that case, is there a state? So anyway, going back to that question, what do you think? What if you were to be the lawyer, the international law lawyer? What would you advise Smiths? Could he declare the existence of a new state of Ontario? Now, if you go back to Article 1, Paragraph 1 of the 1933 Montevideo Convention on the rights and duties of states, which is a codification of customary international law, we know that the moment that what asserts to be a state has certain qualifications, such as it has a permanent population, it has a territory that could be defined, it has a government, and it has a capacity to enter into legal relations with other states, then you have a state. Okay? And if you follow the declaratory theory of international law, the moment a state declares it to be a state, it is a state. And that is, in fact, what happened with the breakup of the United Soviet Socialist Republic, as well as the breakup of the Czech Republic, and then the breakup of the Republic of Yugoslavia. It was on the basis of particular governments declaring themselves to be states. So how do we distinguish those examples from, the Catalan declaring independence, Quebec declaring independence, or maybe that part of Ireland, that part of the UK, declaring independence from the UK?
I think what the biggest problem in reality is, whilst it is it is all very well for us to sort of say, okay, the minute these states declare their independence and sort of say they meet the criteria of the Montevideo Convention, yeah, they do meet the criteria, but they get usurped by the bigger states who sort of come down heavy on them, and they don't want to create another war. And this is the biggest problem. So they back down, and that's the problem with it. That sort of happened in Ireland to a certain extent. It's become less so since the Good Friday agreement has been in place. But you look at Catalonia. They didn't want to create a war, so their first minister, or whatever he was called, the prime minister or whatever he was arrested by the Spanish. So you got a problem there. You look at Bougainville. You've got the PNG government coming in heavy-handed and sort of stepping in on that, and you've got these bigger states come in and stop it because of, physically, and that's the problem, I think.
Very good. So I'm not familiar with the Bougainville issue there. So not familiar, but that's a crucial point, Peter, that you pointed out, because it is actually not enough that a state that alleges to be a state has the four qualifications. When you talk about a government, for example, that government must actually be supreme and independent. So for as long as the government cannot claim to be supreme over its territory, because, for example, in the case of Ireland, how can they do that? You actually have the UK military, which has actually full control over that part of Ireland, or the same thing with Catalan. It's actually the Spanish federal government which is in control of the territory. Then you cannot assert that you have an independent and supreme government. That's issue one. The second issue is the ability of a state to be able to enter into relations with other states. It requires sovereignty and independence as well. And that is related to the first point, that state must be able to assert that it has full control over its territory. So for as long as these are missing as well, so you don't have a government that is independent and supreme, and you don't have you cannot say that that particular government is actually sovereign and independent, and so therefore it has problems entering into relations with other states, then you cannot have a state in relation to Article 1.1 of the 1933 Montevideo Convention on the Rights and Duties of States. So if it were me, I would advise Smiths that under the facts, it would be legally difficult under international law for the state of Ontario to be declared as a state, mainly because it will likely be unable to meet the requirement concerning government and the requirement concerning capacity to enter into relations with other states. We have a point here from Jack. Bougainville had a rebellion forming the Bougainville Revolutionary Army. Okay. They ended up reaching an agreement to form an autonomous region with the capacity to hold a referendum for independence. Oh, okay. So that's pretty new. Oh, I missed that, Interesting. Okay, interesting. Okay. So there you go. Something's going on in PNG as well. Okay, so my advice to Smith. Yes, Dean?
So, Manjo, does that mean then that hypothetically, if this new state that Smith wants to declare,
yes,
if he's got bigger guns than the Commonwealth, basically he can assert his independence.
Yes. And
so kind of that's, I suppose, from what I've sort of been reading, that seems to be the clincher. It's like, well, the Montevideo Convention's all great and well, but if you can't stand up and say, well, I'll fight you to the death, yes, and I'll win, then you might as well just throw it out anyway, because you're not going to get anywhere.
That's the reality of it. Because if you're saying that you're sovereign, and you're supreme, you should have full control. You got to be able to control it. Yeah, makes sense. Coming to me, we're going to arrest you because we have sovereignty, and so that is the basic point there. Okay.
So that current situation in Russia at the moment, or in the Crimea,
yes,
where the Russians have pretty much taken over that waterway.
Yeah.
well, everyone knows the Russians have got bigger guns than the Ukrainians, so
Right.
at the end of the day, they're going to do whatever they want, and they're going to end up getting what they want, aren't they?
Can we have a state of Crimea? Actually, I'm going to ask that in question 5. Okay. So we're gonna go back to that, Dean, in a short while, because I asked that point. We'll go back to that. Okay. So where are we now? Yeah. So you need guns. Okay. You need to be able to assert supremacy and sovereignty over your territory, and to be able to protect and assert your government. Without that, how can you even say that you have a state? Now, there is a kind of a chicken and egg thing, because the moment actually that you have a state, when you think about it, the moment you have a state, and we have the declaratory theory of international law, that the moment the elements of a state are there under the 1933 Montevideo Convention, which is, we said, is a codification of customary international law, the moment you have a state, then that state has a right to territorial integrity. And so therefore, any state that tries to enter the territory of another state would be in breach of international law, right? So you shouldn't need military, you shouldn't need a military for that, correct? That's kind of a chicken and egg thing. But if we're talking at the first instance of the emergence of a new state, it is crucial that you need to be able to show that you do have sovereignty and supremacy in your territory, and that you can protect your own government, because in the absence of that, you cannot have a state.
We've even got it here, Manjo, in Australia.
Well,
You look at the Hutt River province.
okay.
That tried to create a new state, and Australia's just ignored, Prince Leonard and all his other cronies and things like that.
Right.
And they just think he's a huge joke. So of course he's unenforceable. It's just, it is a joke, really.
Okay. Okay. Very good. So we're clear? No questions so far? Let's move on. Let me just go to the quiz for now, and then we'll backtrack and we'll do the other questions just before we forget. Let's just go to the quiz, and then we'll go back to question 3. Because what was question 3 about? It's about the artificial islands. We're going to go back to that. Let's go to quiz 4 for now. Can I get somebody to go through? This is a relevant point, because when you think about it, if Israel wanted to, it could control easily the state of Palestine. Well, not really easily, because you'd have I'm not even sure if you can call them terrorists. The Palestinians are trying to expel Israelis. You can't call them terrorists on their own land. So, sorry, it's my Western-centric idea there. But when you think about it, it would have been possible for the state of Israel to maybe invade the state of Palestine and, kick out its government, right? And in that case, would that cease to be a state? Because when you look at it, for example, are you familiar with Rome, or Vatican, rather, Vatican? You're familiar with the Vatican? Is that a state? It doesn't really have an effective military. I mean, it has the Swiss guards, but if another nation invaded it, it doesn't have an army really. So do you really need an army in order for there to be a state? And do you really need that, you have a government that, so Vatican is a state. That should just be clear, even if it has no standing military, because it only has the Swiss guards. So anyway, going back to Palestine, can somebody read the quiz question for us? Do you find it interesting so far to be talking about public international law? Right? Okay, questions so far. I mean, sorry, somebody read question 4? Or was there?
I'm going to read it for you. I'll read it.
Okay, thank you, Dean.
Palestine declared independence and its existence as a state in November 1988. As of 2015, 136 member states of the United Nations recognise the state of Palestine, with over 50 others, including the United States and Israel, do not. Which of the following statements is the most correct answer? 1. Palestine is a state because it's recognised by a majority of the member states of the UN. Palestine is not a state because the United States and over 50 other states do not recognise the state of Palestine. Palestine is a state because it possesses the qualifications of a state under the 1933 Montevideo Convention. Palestine's existence as a state depends on whether it or not it is a member of the United Nations. All of the answers are wrong.
Okay, I'm going to change these one, not bullet points, but letters. Can I just get you to provide an answer in the chat box? What you think is the correct answer? Is it A, B, C, D, or E? Now, again, note for those who are taking the quiz, the quiz questions are shuffled. So even if you figure out what the correct answer is, do not rely on the letter. Okay, very good. So I've seen answers there. Go on. How about the others? I've seen 1, 2, 3, 4, 5, 6, 7. Okay, answers. Okay. Very good. Very good. So you've got the correct answer there. So what's the point? Very good. Heidi, Tony, Dean, you've got the correct answers. Very good. What's the point about this recognition? Is there a requirement for recognition for there to be a state? And what if there is a so-called state? It has recognition, but it doesn't possess the qualifications for a state. Maybe because it doesn't really have an independent government. Can there still be a state? So these are critical questions for us. What do the others think? Can I get, and why do you cite C as the answer, and not A, for example, and not B, for example, and not D? Can somebody try to provide an argument?
I think it's because the two issues are separate. Recognition is not necessarily, does not preclude a state from being a state.
Yes.
It doesn't stop it from doing business. It doesn't stop it from making its own laws and so forth. It doesn't stop it from fulfilling the qualifications under the Montevideo Convention, regardless of whether it's been recognized by everyone or no one. It's still able to do that.
Very good. So recognition by other states or by a majority of the states is not a precondition, is not a qualification that is crucial to the existence of a state, not under the 1933 Montevideo Convention on the Rights and Duties of States, which we said is a codification of international law. We're clear about that? Clear. Now let me ask you a question then. Was it here? We're just going to jump a bit, okay? Because this is related to quiz 4. So we know the answer to quiz 4. We're clear, right? We're clear. Okay, so we're clear about that. Yeah, so very good from Kathleen. Under the 1933 Montevideo Convention, it says that the political existence of the state is independent of recognition by the other states. Thank you, Kathleen. Well done. Very good. Now, I'm just going to jump to question 5 because this was raised earlier, and I'm going to raise a point in a short while. I'm just going to read it for you, and I'm hoping you're familiar with this. So in 2014, Russia invaded the territory of Ukraine and annexed Crimea. Okay? In 2015, the Autonomous Republic of Ukraine was established as a state. What is the status of the ARU as a state under international law? Let's assume that Russia recognizes, obviously it does, recognizes Crimea as a state. Let's assume Cuba recognizes Crimea. Let's assume even China will recognize Crimea, and a few other, African governments recognize Crimea. Did I pronounce it correctly? Would it mean that there is in fact a state of Crimea? Okay, from Catherine, but its government is not independent of Russia. Okay, that can be a question of fact. Well, let's assume that it asserts it is an independent government. From Peter,
the Crimea was actually a part of the Ukraine prior to the existence of the USSR.
Okay.
And when the breakup of the USSR came back, it happened in 1990-91. Crimea and Ukraine were put to, they were put together. They were all one state. Crimea was part of the Ukraine. However, the Russians, because they had resettled a lot of Russian people there, believed that it should belong to them.
Okay.
And this is what all the problem's all about.
So, do we have a state of Crimea then, or not? Russia,
No.
Russia recognizes it to be a state. Let's assume Cuba, which, close to Russia, and all the other states sympathetic to Russia, they all recognize the independent state of Ukraine.
I would say that's irrelevant, Manjo.
Yeah?
I would say it's irrelevant who recognises them. It would come down to whether they meet those definitive requirements in the Montevideo Convention.
Very good. So, as a convention, sorry, did somebody want to say something? No? Okay. As a matter of conventional international law, what you would say is a safe traditional answer. The safe traditional answer should be that Ukraine, the state of Ukraine, the state of Crimea, the Autonomous Republic of Ukraine, which is actually the so-called state of Crimea, wouldn't really be a state under international law, as correctly pointed out by Dean. Regardless of the recognition of other states, it doesn't meet the requirements. For example, maybe, lack of an independent government because it is actually controlled by Russia. But more importantly, there appears to be the emergence of customary international law that would not permit, and this is according to the European Union, that it will only consider a state to be a state if its frontiers and its territory would have been respected by other states. So if you do it by invasion and then set up another state, that is likely to be a kind of a breach of international law, because there is a breach of international law. Imagine, the territorial integrity of Ukraine was violated by Russia in doing this. And so that will not be consistent with international law, and chances are it will not be a state, regardless of the number of states that might recognize the state of Crimea. We're clear about that. That's a safe conventional answer. The question, however, is what happens if Russia, engages with the so-called state of Crimea anyway? They enter into treaties. Would there be a breach of international law by Russia, by perhaps even China, trying to negotiate with the so-called state of Crimea as an independent state? Would that be a breach of international law? Did you get my question? So what if there were, entered into treaties, trade relations? Yes, Dean?
Would it matter? I mean, states can engage in agreements with companies. So is it really going to make a scrap of difference whether or not the ARU is a state or not? I can't see how it would be relevant. Like, it wouldn't be illegal or legal. It would just be, that would be their business, and there'd be no real. Is that right?
That's right. That's correct. So that's an important point, Dean, because it brings us back to the case of France versus Turkey, where there's nothing in international law. If we know international law to be based on the consent of states, there is nothing that would prevent or prohibit a state from recognizing anything as a state. It wouldn't be a breach of international law because Russia, for example, didn't agree to that kind of international law. There is no customary international law to that effect. So if Russia decides to recognize the Autonomous Republic of Ukraine, Russia can do that. I mean, it's within its power. There is no rule of international law that will prevent that. If they decide to even have diplomatic relations, Russia can do that. But neither can the other states be compelled to recognize the so-called Autonomous Republic of Ukraine. Okay, very good. Very clear about that? Now, this is Waterworld. Catherine was saying she didn't like the movie, but her husband did. I actually like that movie because I like Kevin Costner a lot. It was a very interesting movie. And this relates to question 3, where, I'll just read it for you because we're kind of running out of time. Here in question 3, Jameson Goodwill, a brash and visionary billionaire, created a series of artificial islands somewhere in the high seas that was outside the territory of any state. He then developed artificial islands to make them habitable and invited people for a fee to become citizens of this new state that he was creating. Over 5,000 individuals subsequently started living in Goodwill's islands. Goodwill has come to you for advice on whether he can declare the existence of the new state of Goodwill. Advice, Goodwill. You could have somebody.
Manjo, because it's not, it's an artificial, man-made thing.
Yeah.
So it can't be a state because it's not proper land.
Very good. So Dean here has provided very good the case of Reed Duchy of Sealand in 1978, where the General Federal Administrative Court ruled that if you talk of territory, it must be a natural segment of the Earth's surface. You cannot have an artificial island. And that decision of the German Federal Administrative Court is part of general international law. You're part of the general principles of international law, that the kind of territory you have must be one that is part of the natural segment of the Earth's surface. So you can't have artificial reefs. So that is the correct answer there. And so in the case of Waterworld, assuming that there were aircraft carriers because of war, and you saw them somewhere in the high seas, and then you put up an island there, people live there, you cannot have a state because they're not natural segments of the Earth's surface. So we have to be very careful, because I recall, sometimes it appears on Gumtree, is it, or even on eBay, where people are selling parts of the moon. I'm not sure if it's a joke, but there are some people, selling parts of the moon. You can own this and you can own that. Somebody can end up selling us, a vision of Waterworld, and say that, you're going to be a citizen if you pay this much. So that can be dangerous. Okay, any questions? I think those were the questions I wanted to ask. Do you have any questions, comments before we end tonight's session? Yeah, snake oil salesman. That's true. Questions, comments? We're good. We're good. No questions? Okay then. So thanks for joining tonight's session, and I'm going to see you next week again. Not next week. Next week is term break for us. So I'm not seeing you next week. I'll see you the week after. Okay, enjoy your term break, and see you 2 weeks from now. Bye. Thanks for joining me. Bye. Thank you, Dean.